Hello again and welcome to the webinar today. My name is Debbie Brenneman. I'm a partner in Thompson Hine's Labor and Employment Practice Group in the Cincinnati and Dayton offices. And I am delighted to introduce my colleague and co-presenter today, my partner Amanda Washton from our Los Angeles, California office. Today's webinar is the first of two sessions that will review employment laws and local regulations and the distinct challenges California employers face on hiring, wage and hour requirements, and employee protection. These areas can be vary significantly from state to state and even with federal requirements, but there are particular challenges in California. And for the next hour today, we will focus on hiring and onboarding employees in California. Before we begin, we do have a few housekeeping items. Today's program is being recorded and we will send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have questions during the webinar, please feel free to use the question box located in the control panel on the upper right side of your screen. If we have time at the end of the presentation, we will get to as many of those as we can. But thank you very much for your interest today. We're delighted that you are joining us, and I am happy to hand it over to Amanda to begin.
Thank you, Debbie. As an intro to the California employment law arena, I wanted to focus us on how to start or the outset of the employment relationship. And that starts with job posting and pay transparency. The California has enacted a Pay Transparency Act, and the purpose of that act is to promote pay equity and transparency. There was a lot of data circulated in California about how women were underrepresented, and those Black and Latino Californians were very underrepresented and not subject to the same pay as others of less protected class. So the California legislature enacted this statute to require employers with more than 15 employees to include the pay scale for all positions in job posts and job postings on their own and on their third-party websites like LinkedIn or Indeed, to provide the pay scale for the position not only upon request but on the postings themselves. And a lot of employers in California struggle with what to do about that because they don't necessarily have the specific salary level set forth for every job position at the time of posting. So I usually guide my clients to provide an accurate pay range so that there's some wiggle room within the range, but it is still accurate and they're compliant with this statute. In addition, private employers of 100 or more employees now must compile an annual pay data report with very detailed information on pay, the hours worked, the number of employees and categorize those employees by race, ethnicity, and sex across all different job categories, and submit that to the California Civil Rights Department. That's our California, it used to be called the DFEH, or the Fair Employment Housing Department. It is now called the Civil Rights Department. And they have the requirement to, on a yearly basis, submit all this information about your employees to the CRD. That is a very, sometimes it can be very difficult for employers to try to figure out exactly which employees apply to this 100 requirement. It includes labor contractors, it includes remote workers, it includes any employees who actually do any type of work in California. The 100 rule, it really is for all employers with 100 or more employees, even those outside the state. But as far as who to include on the pay data report, those are questions that a lot of employers have. And the Civil Rights Department has a very lengthy fact sheet that I put in the slide that you can look at that gives a lot of answers to some of those questions, but we do help our clients navigate through that and comply with it. It's very important to do so because the CRD can and does obtain monetary penalties against employers who fail to file the required report, and they actively pursue non-filers. And it usually is done and required on a yearly basis, and it's around mid-May for the year prior. The next thing that I want to focus on for California initial hiring processes and procedures is the background checks and the California Ban the Box law. This is under the California Fair Chance Act, which, like I said, is known as the Ban the Box law. And it went into effect in 2018, but it generally prohibits employers of 5 or more employees from asking about an applicant's conviction history before making an offer. The purpose of this was to reduce the barriers to employment for individuals with criminal backgrounds. But it does require, and it does give employers the opportunity to conduct the appropriate background checks if the job requires it. But it has to be specific to what the job requires. It used to be that a lot of employment applications literally had a box to check if they've ever been convicted of a crime. That is prohibited. But once an offer is made, the employer can conduct and pull a background check, but they have to make an individual assessment about the job applicant's criminal history, and they have to look into those specific factors like the nature and the gravity of the crime, the time that's passed since the conviction, and the nature of the job sought. So if it's a bank, for example, who are looking to hire a teller, obviously a criminal background check that pulls fraud or theft or embezzlement, that would be something that would be subject to revoking that offer to somebody who works in a place like a bank or a law firm, any place that would have an employee with a position. The nature of the job sought is definitely one of the assessments and evaluations that an employer can do to determine whether or not it's appropriate to revoke the job offer. If the job offer is revoked, notice has to be given, and a copy of whatever was background check that was pulled has to be provided to the employee, and they have to have an opportunity to respond. So there are specific procedures in California. It can be done. You can conduct a background check, but it can't just be for every job. It has to be narrowly tailored to the type of position, and the procedures need to be followed. There's also local ordinances like the LA County Fair Chance Ordinance and federal laws like the Fair Credit Reporting Act that also require employers to include compliance on job postings and provide notice of the intent to conduct a background. So you can pull a credit report, but you have to let the employees know at the time an offer is extended that it's subject to a background check or report. Notice has to be provided.
Just to jump in for a minute, Amanda, we multi-state employers really need to pay attention to these two issues across the country. Pay transparency laws have been really on the rise in the last couple of years. Outside of California, there are a dozen other states that have some type of pay transparency statutes, and they're all a little bit different. The District of Columbia also has a pay transparency statute, and ban the box laws are becoming more and more prevalent as well. So while California has some of the most tricky of laws, these are certainly there in other states and something that folks need to be aware of.
Great. Thanks, Debbie. The other thing I wanted to make sure California employers are aware of is we have California-specific required trainings and notices. We've had for a couple of years now a sexual harassment and prevention requirement that's provided in our government code and our statutory framework. All employees must be trained within 6 months of hire, and it must be repeated every 2 years. Non-supervisory employees take a 1-hour training session, and supervisors have to receive 2 hours of training. Lawyers and HR professionals can conduct those trainings, but we often advise our clients there's a lot of portals and free versions of these California sexual harassment trainings that can be utilized by employers, and we can help navigate our clients to those. These trainings must include anti-bullying training. It's not just a sexual harassment training, it's all different types of harassment, and that is statutory required in the code. In addition to sexual harassment training, as of this last year, July 1st, Workplace Violence and Safety Act was enacted that requires workplace violence and training as well. California employers must establish, implement, and maintain a workplace violence prevention plan, and it needs to be in writing. That includes prohibiting employee retaliation, accepting and responding to reports of workplace violence, employee workplace violence training and communication, emergency response. Basically, the workers have to be given information on who to call or who to talk to if they believe they're under threat of violence. And workplace violence hazard assessments must be done, and violence incident logs need to be maintained. This really happened after there were a lot of workplace events that were occurring, so this was enacted to prevent and help protect the workers from incidents of that nature. There's also specialized training requirements in California depending upon the industry. Human trafficking and training exists for hotel and motel industry, and mandated reporters like teachers and healthcare workers also receive child abuse reporting training as well. In addition, California limits the employer's ability to require a driver's license. This is new. It used to be a lot of applicants, another box to check whether or not they have a California driver's license. That is no longer allowed starting in January 2025. It became part of California's Fair Employment and Housing Act, which is California's very lengthy anti-discrimination law. And it prohibits employers from including a statement in their job postings or applications that they must have a driver's license. This is unless it's a hire for a driver, somebody who's obviously going to have an essential job function of being a driver, then you obviously can require a driver's license. But the purpose of this law was to help facilitate the employment for non-drivers who rely on public transportation, biking, walking, and is just another example of California's way of encouraging work protections for underrepresented portions of the community.
Another key feature in California employment law is the famous ban on non-compete agreements that exists in California. Last year, that ban was extended to include the fact that California-based employers cannot enforce non-compete agreements against employees who reside and work outside of California. So that was expanded by the legislature. It has been subject to a court challenge in Massachusetts already, and Massachusetts said, no, California, you can't do that. We're going to apply our law and enforce the agreement. But that's just the first, I'm sure, of many challenges to come. So for employers who do reside in California or have employees in California, it's tricky how to protect sensitive information and relationships, but there are still tools, of course, that you can use. One of those is confidentiality agreements. Confidentiality agreements can and should be used to protect a company's trade secret information. It's sensitive and confidential business information and practices. Key considerations for these agreements is they really should spell out, not in an exclusive way, but give the employees some examples of what is this confidential information. Customer contact information, perhaps, formulas, proprietary practices, pricing, margins, strategies, outline what some of those things are, because if you get in some kind of enforcement action, a court wants to see that you've given fair warning to the employee about what that information is that is being protected. And the agreement should also outline what's a permissible and an impermissible use. So permissible, of course, would be using it for purposes of doing your job or within the company. Impermissible use would be using it for the employee's own benefit or the benefit of any other third party, outside of their employment. So define what type of use is okay and what's not okay. Of course, there are certain limitations on when confidentiality agreements can be used. Employees under California law cannot be restricted from reporting violations of the law. They can't be used to prohibit the disclosure of unlawful acts like harassment, discrimination, or retaliation. And outside of the employee context, businesses settling disputes with consumers cannot condition a refund or other consideration on a consumer agreement not to make statements about the business. So if you're using those with consumers, some limitations on those as well. Another way around the non-compete ban and protect information is to use intellectual property agreements. So employee inventions agreements are governed by California law as well. Employers cannot claim ownership of inventions, though, that were created by the employee outside of work hours and without company resources, unless that invention relates directly to the employer's business or anticipated work of the business, or results from any work performed by the employee for the employer. So if it's linked to their work for the employer, it's information that they gained, that can be protected. If it's something completely different and they're working on their own project outside of work hours in their garage or whatever, and company's not paying for it, that can't be restricted. IP agreements should specify the assignment of rights to the employer for all of the work-related inventions, and should also make sure that they include post-employment IP protections as well. Another new piece of the puzzle with regard to IP agreements is that now you can't, you also have to be sure that those are not being used outside of California for California-based employees. There is also a new statutory provision that could subject employers to damages and civil penalties if they have an IP agreement with an employee outside of California that has these restrictions, that has a, sorry, if they contain a non-compete provision. So what I was trying to say inartfully there was that oftentimes IP agreements will contain a non-compete provision. Employers fix that for California employees by just removing that provision. Now California law says if you're a California employer, you cannot include those non-compete provisions outside of California either. Another important tool to protect your assets and interests is to use non-competes. So under the California Uniform Trade Secrets Act, it does provide protection to employers for trade secrets. And trade secrets, of course, constitute information that's valuable to the company, not easily accessible to the public. It is things like formulas, you know, the secret sauce, processes, strategies, could be software, can be client lists if they're maintained confidentially. But a trade secret cannot be protected if the company doesn't take reasonable steps to protect the secrecy of that information. And I'll talk a bit more about that in a moment. Remedies for misappropriation of trade secret: employers can go after the employee, the former employee, and the new employer as well for damages if they have profited from the use of the trade secret information. And trade secrets can form the basis for injunctive relief. So even when there is not a non-compete in place, if an employee goes to a new employer and is using your trade secret information there or for the employee's own benefit, you can seek action to stop them from doing that, and in certain cases may even be able to preclude their employment if they are using that trade secret information. So it's a very, very valuable tool. You can sue both the person who stole it and the new employer, and again, seek both injunctive relief and damages for that. But the time to really set yourself up to be able to enforce a trade secret action to protect your trade secrets is now. Going back to the point that I made earlier, that an employer has to take reasonable steps to protect the secrecy of that information. If you're not doing that right now and the employee steals the information and starts using it, there's nothing you can do to backtrack and then start protecting it. So you really should be auditing your processes, auditing your policies, making sure that you have those protections in place, that you can identify your trade secret information and you can show that you're protecting it. So some ways you can do that. First of all, go back to those confidentiality agreements. Anyone in the company who touches trade secret or confidential information should be signed up to a confidentiality agreement. It's one thing that courts look to see if you're taking steps to protect the secrecy of that information. Of course, limit access to information, both when there are physical copies of it, maybe there's access to certain parts of the office or the plant that contains secret information. Don't allow clients to go through there. Don't allow employees who don't have reason to know that information to go through there. Certainly make sure that electronic information not only is isolated from those who don't have a reason to use it, but also even that it is labeled, that there's a stamp on it so that if it's printed out, there is a confidentiality designation. Make sure that when you're doing employee training, that there is a component of protecting trade secret information, that you're reminding them. It should be in your handbook, it should be in your confidentiality agreements, but also employees should be trained. This is what we consider to be our trade secret information. This is what you can do with it. This is what you cannot do with it. It is very important to the company, and we will take steps to protect this information if it is misappropriated. Another thing to do is to make sure that you have the protocols in place for the departure of key employees. Those folks who have the special relationships with clients, those folks who are in charge of the strategies, those folks who are developing the products or services, those folks who, if they went to work for a competitor, could really strike a blow to the business if they use that information. So develop some protocols. Make sure that when those folks exit, you are reminding them of what their obligations are, both with regard to any confidentiality agreements and with regard to the handling of the trade secrets. Make sure that you're thinking about how do you make sure you know what you're doing. I live in this space a lot, and it is very common for an employee to come forward and say, yeah, I'm going to go back to school, or I think I'm going to retire. I'm not sure really what I'm going to do. So the client thinks everything is fine and good, and then a couple of months later they show up at their competitors and they are using their information. So even if you think, particularly if you know the key employee is going to a competitor, but even if you don't believe they are, if they are a key employee, make sure you're doing some due diligence. Go back through their emails for the last 30 or 60 days, see if there are any telltale clues about what they've been doing, or if they've been sending information to themselves, or they're having communications with your key clients about their departure, things like that. And really consider preserving, if not having a search done of the hard drive for their computers. Make sure you're telling them to return all flash drives that they may have used. With regard to the hard drives, companies should never themselves say, hey, IT department, would you take a look at this person's laptop and see what they've been doing for the last 3 weeks here. Should never do that, because you'll change the metadata. It should be done by a forensic vendor who can identify what has been done with a computer, what documents have been accessed, if scrubbing software has been used, what flash drives may have been used with the device. There's a whole host of information. And when you're talking about somebody who's very key to the company, if you don't feel a need to have that forensic review done immediately, just take the hard drive out of the laptop, hang on to it for 6 months or a year in case something comes up, because once you place it back into the system and information is written over it, you have lost a potential treasure trove. So that's critically important. Make sure your remote use policies with regard to trade secret information is up to date. Most companies are now in some type of a hybrid situation, so folks really are using information not just within the four walls of the office, but in their homes more and more, in their home offices more and more, from Airbnbs, from the beach, from Starbucks, from wherever. Make sure you have policies in place that require employees to be in a private spot without others present if they're reviewing your trade secret information. Make sure that you have guidelines on how they should be deleting information, or if they have hard copies of information, how that should be disposed of when they are finished with it. There have been cases in the last couple of years where a lack of an appropriate remote use policy has voided an ability to enforce a trade secret action. So these policies are very important. And finally, consider monitoring policies. And what I mean by that is there are a variety of means to monitor when employees are accessing key information. It could just be a random kind of monitoring, sort of like random drug screens. It can be a document-specific monitoring, that anytime a certain library of key documents is accessed by anyone, there is a red flag is sent to IT, and someone takes a look at whether that's an appropriate use. And there's also monitoring policies that focus on volume. If an employee is accessing an unusual number of documents in a particular time period, again, red flag goes up and you can make an assessment about whether there's a business reason for that, or, oh geez, what are they doing? They seem to be gathering a bunch of our confidential information. Maybe we have a problem here. So those are some ways you can protect your trade secrets right now. Another trade secrets tool, of course, is the Defend Trade Secrets Act that we've had for a while now. A couple of key things about that: it provides immediate jurisdiction with the federal courts, which is usually more preferable in a trade secret action. And it provides the opportunity to obtain punitive damages and attorney's fees in a successful trade secret enforcement action. And California-based employers or multi-state employers, of course, should know that outside of California, in most states, non-competes are alive and well, and it appears that they will continue to be alive and well. As most everyone knows, the Federal Trade Commission earlier this year issued what would be a virtual ban on non-competes. That came to a quick legal challenge, and courts in Texas and in Florida struck down the ban. The court in Texas issued a nationwide order banning the FTC's ban on non-competes, so allowing non-competes to continue. Many think that in the Trump administration, with the changes to the FTC board, the commission itself, that there will likely, there have been appeals of that litigation. It's expected that the new commissioners, once there is a Republican majority on the commission, they will likely drop those appeals. That's what many commentators are speculating at this point. That being so, there are still many state-based restrictions. Upwards of 30 states have some type of limitations. Some other states have bans, a few other states besides California, but there are a growing number of limitations based upon salary thresholds or positions. And I would anticipate that with the FTC ban going by the wayside, we're likely to see another uptick in state and local laws based upon non-competes. So certainly stay tuned on that. And with that, Amanda, I'll give it back to you to talk about independent contractor agreements.
Thank you, Debbie. Yes, independent contractor agreements are one of the key issues and a big topic in California. We have a California Labor Code statute that defines independent contractor, which says it's any person who renders service for a specified recompense for a specified result under the control of his principal as to the result of his work only, and not as to the means by which such result is accomplished. What does that really mean? That's been the bane of a lot of employers' existence, or that definition, and how to define whether they can create an independent contractor relationship as opposed to an employment relationship has been a big issue. We have not relatively recently, it was actually in 2019, AB 5 was enacted, where that was enacted by the California legislature to ensure that workers are currently who are currently being exploited by being misclassified as independent contractors instead of employees have the basic rights and protections they deserve under the law. And their intent was to make sure that all workers in California have the protections of California law, such as minimum wage, workers' compensation, unemployment insurance, paid sick leave, paid family leave, all of the requirements that I'm actually going to go over a little bit more in the next webinar in February, and how to comply with all the California ticky-tacky requirements. But one of the ways that the legislature noticed that California employers were trying to avoid some of these very difficult and stringent requirements is by creating independent contractor agreements for their workers. And so the California legislature reacted to that with AB 5. AB 5, what is that? It is a way to define workers and create a presumption that a worker in California is an employee as opposed to an independent contractor. And that was a way to make sure and capture more workers in California will be considered employees as opposed to independent contractors. And it created the ABC test, which is A, worker has to be free from the control and direction of the hiring entity. B, the work has to be performed outside the usual course of the hiring entity's business. and C, the worker is engaged in an independently established trade, occupation, or business. What's the most difficult factor, I think, that employers struggle with and has really been a significant change in the law once the AB5 statute was passed, work performed outside the usual, or B, trying to hire an employee to perform work, it has to be outside the course of the hiring entity's business. There are exceptions to the rule. Certain licensed professionals in the statute itself created some exceptions, like lawyers, architects, and real estate agents. And there is a salesperson exemption and a creative professional exemption, and the business-to-business exception, which still use the test that was used prior to the enactment of AB5. That's the Borello test. The AB5 test came out, it's maybe easier to note that the AB test came out with this famous Dynamex case, and that was same-day courier and delivery service that changed all of its workers or drivers in California in 2004 to independent contractors. They were sued and received a class action and were certified as a class action, and that resulted in the ABC test. The Borello test is different. That's a multi-factor test where the most important factor was and is the right to control the means and manner in which the work is performed. And they have other secondary factors like who controls the equipment, the belief of the parties, the opportunity for the contractor for profit and loss, their own businesses. Those are secondary factors under the Borello test. But it's important to know that both tests apply, because if one of these exceptions that I just went over exists, it doesn't mean they're automatically going to be considered an independent contractor by the courts. You still have to make sure that you go through the Borello factors or the multi-factor test to make sure that these are independent contractors. Next slide, Debbie. We do have legislative updates to these exemptions, in addition to the doctors and dentists and lawyers and architects that were classically part of the AB5 exemption. We have accountants and commercial fishermen. We have in California AB 2257, which created even more exemptions. And there's now 109 categories of workers exempted from the ABC test. These exceptions really do swallow the rule. So it's really important to make sure that you're looking at your workers and whether or not in your business to make sure they're within one of these exceptions. They're heavily litigated. One of the exceptions that were addressed in AB 2257 is the referral agency exemption, and that was the statute that basically said that workers in referral agencies that provide delivery or transportation services are subject to the ABC test, which is somewhat counterintuitive. So certain gig economies and travel gig services, or gig and travel services, were considered, had to comply with the ABC test, while other gig economy services or referral services like dog walking or handyman services were subject to the Borello test. And that was definitely litigated and still is being litigated to date. In 2020, though, Proposition 22 was a successful ballot measure that allows app or gig-based transportation and delivery services to be treated as independent contractors if certain conditions are met. So there are, legislative exceptions and court-created exceptions that are still existing today. So it's really important to evaluate whether your workers are subject to the appropriate tests before entering into independent contractor engagements with them. Next slide. It is very dangerous to misclassify the workers as independent contractors as opposed to employees. It's an issue of great significance for employers, because if a worker is classified as an employee, the employer bears the responsibility of paying their Social Security and payroll taxes, unemployment insurance taxes, state employment taxes, providing workers' compensation insurance, and of course, complying with the labyrinth of state and federal statutes governing the wage and hour laws and working conditions of the employees. So the EDD will come after any employer who misclassifies their workers as independent contractors as opposed to employees. There can be EDD claims. The California Labor Commissioner and tax authorities will seek to audit employers' payroll and assess back payroll taxes along with penalties and interest. There's been individual and class action claims. There is of course, a labor code statute in California, 226.8, that makes misclassification a violation and have enacted penalties ranging from $5,000 to $25,000 per violation and back pay and benefit liabilities. These issues of misclassification often trigger PAGA claims as well. I'll talk a little bit more about PAGA a little bit later and also in the next February webinar. And again, misclassification could make employers underinsured for workers' compensation insurance and also not allow unemployment benefits for these workers. So it is very important to make sure you're classifying your workers accurately. You can still create independent contractor agreements, and I have a lot of clients asking how to do that, and it can be done. You just have to be very careful about making sure the scope of the work and the services provided by the worker are consistent with one of the exemptions of the ABC test, or if they fall within if it is within the exemptions that the agreement falls within the Borello test. You must clearly describe the services and the scope of autonomy and expertise used by the contractor in the contract. We often include terms that establish the contractor's control over the manner and method of the work in the contract itself. Sometimes we put clauses like the ability to hire subcontractors, they choose the location of their performance, they supply their own supplies and materials, the method of payment or termination is in the control of the contractor. The more clauses in an independent contractor agreement that provides the control is in the contractor's hands, the better. And the biggest thing to make sure under the ABC test is to make sure that the work described in the contract is outside the scope of what is in the engaging business's enterprise.
It is important to remember that there are tests beyond California as well, and many competing tests for establishing or determining whether someone is properly classified as an independent contractor. Last year, the Department of Labor issued a new independent contractor test, calling it a new economic realities test. In fact, it was really a return to a prior test that had been used, but under this Department of Labor test, the Department of Labor will look at 6 factors to determine whether someone is properly classified as an independent contractor or is really an employee. So when the Department of Labor is conducting an investigation into issues, these are the things that the department is going to take a look at. First is the opportunity for profit or loss, depending on managerial skill. And that doesn't just mean if they work more hours, they get paid more. That means, is this person investing in their own business? Are they providing things? Are they doing marketing? Do they have, again, not only an opportunity to make more money, but are they subject to loss if they're not managing things appropriately? The second factor is the investments by the worker and the potential employer. So things like, is the worker bringing, his or her own tools, own equipment, own supplies, perhaps investing in the cost of traveling, those kinds of things that the department will look at. Third is the degree of permanence of the work relationship. So if you have someone who has been providing services as a quote unquote independent contractor for a few years, then that's going to be looked at as askance and probably weighs more in terms of that being an employment relationship rather than an independent contractor relationship. Not saying that can never happen, but degree of permanence is certainly one factor that the department will take a look at, and other agencies. Probably the biggest one, and the department says no one of these factors is determinative. It's a balancing of all of them. But a big factor certainly is the nature and degree of control. To Amanda's point, in terms of things he set forth in an independent contractor agreement about the contractor retaining control of how, when, and where to provide services, to the extent possible. this factor looks at that. Certainly if there is a worker that is being given performance reviews or has a supervisor at the employer that they report into, that again shows a degree of control that probably tilts in favor of an employment status rather than independent contractor. The next factor is something that is analyzed under the ABC test, really, that Amanda referenced, which is the extent to which the work performed is an integral part of the potential employer's business. This is not as strict of a factor as it is in the ABC test, but nonetheless something that is reviewed. And then finally, the skill and initiative that individual brings in terms of their ability and their performance of the tasks at hand.
Debbie, if I could hop in there
Sure.
really quick, sorry to interrupt. There was a question I saw. I am going to try to leave those to the end, but it came up timely. The Borrello test was one of the questions, and I just noticed that this Department of Labor test that you just went through is very similar to the multi-factor Borrello test. And so there's a lot of overlapping principles there. So yeah, the Borrello test has all of these. It's an 11 factor test, so I didn't put it in a slide, but I'm happy to share that with you after or towards the end of the presentation. But there is, like I said, overlap between the Department of Labor test and the Borrello test.
Yeah, thanks, Amanda. In fact, to your point, there are just a variety of tests. So it really depends upon the state you're dealing with, depends on the agency you're dealing with. Even within the state, the IRS, as opposed to the Department of Labor, has its own 20-factor tests. Those factors look a lot like, these 6 factors, but obviously there are more. So if the IRS is examining something, it's going to look at it in a way that's different from the Department of Labor. State to state, these tests change, and even within the state, there can be a variety of competing tests. So I sit in Ohio, and here in Ohio, the Ohio Civil Rights Commission, the Workers' Compensation Agency, and the Unemployment Agency all have different tests that they use when they are taking a look at whether someone is an independent contractor or should be properly classified as an employee. So it's another employment law issue that is clear as mud. Amanda, then I will give it back to you to start talking about arbitration agreements.
Yes, another clear as mud portion of California law. But I'm happy to say that mandatory arbitration agreements are indeed enforceable even in California. Much to the California legislature's chagrin, I might add, they did try to make arbitration agreements unenforceable. There was a California Labor Code statute 432.6 that required, that stated that California employers were prohibited from requiring prospective and current employees to waive any right, form, or procedure for a violation of the FEHA statute, which is what I went over before, which is California's anti-discrimination law, or the California Labor Code. All of those wage and hour ticky-tacky rules that are in the California Labor Code, they enacted this statute to prevent any arbitration agreements from being enforceable on any of those issues. Luckily, that was held in the Bonta case, the Ninth Circuit case, that was preempted by the Federal Arbitration Act. So that Labor Code statute is preempted, and you can have arbitration agreements on issues involving FEHA and the California Labor Code. Arbitration agreements are one of the things that employers really look for when hiring workers in California, because they do require that the employees resolve their disputes through the arbitration rather than a court litigation, which can be very extensive, time-consuming, and very expensive. California arbitration agreements are governed by both the federal law, the FAA, and California law. However, the FAA does preempt the conflicting state laws. So we often look and make sure the arbitration agreements, where applicable, are we include it to be enforced under the FAA as opposed to California Arbitration Act. However, even though mandatory arbitration agreements are enforceable, they still cannot be unconscionable. There's a famous California case, the Almendarez case, which went through a lot of another multi-factor test that employers need to be aware of. But the key of this multi-factor test is that arbitration agreements have to be both procedurally and substantively conscionable. They cannot be unconscionable. And courts apply a sliding scale for procedural and substantive unconscionability. So a mandatory arbitration agreement would obviously not be procedurally conscionable, but if employers are gonna require that their employees sign a mandatory arbitration agreement, it's very important to make sure issues of substantive issues are fair and equitable to the employees. So for procedural issues, those address circumstances on how to, at the time of the contract negotiation and the formation of the contract, and it focuses on the unequal bargaining power or oppression between the employer and employee or surprise. I mean, even if you provide a mandatory arbitration agreement for an employee to sign upon hire, you should give them some time to consider it and not just say you're not starting unless or until you consider it. You can, but again, that it would be procedurally an issue if there are, and it would be important to make sure your terms in your contract really are fair to both sides. So, and substantive issues are just general fairness as to the actual terms, and anything that could create a one-sided result. Some procedure or substantively unconscionable terms I've seen are where an employee has to arbitrate their wage and hour issues, but if there's a trade secrets issue, the employer can seek that in court, and that would not be substantively, it would not be enforceable in California. Next slide. There are federal exceptions to the arbitration rule. There is, effective in March of 2022, was the Ending Forced Arbitration and Sexual Assault and Sexual Harassment Act, and this was a reaction to the Me Too movement, and actually amended the FAA so it applies to all states' arbitration agreements, and allows employees to bring individual, joint, and class and collective action claims for sexual assault and sexual harassment in court, notwithstanding a mandatory pre-dispute arbitration agreement or a waiver of those claims in that arbitration agreement itself. It applies to any state, tribal, or federal dispute that has not arisen at the time of making the agreement, and courts have the exclusive authority to determine whether a dispute or a claim is covered by the statute. Essentially, there's just no way of getting a sexual assault or sexual harassment claim out of court any longer. One of the issues that employers ask to try to include in their arbitration agreements are class action and PAGA waivers. Class action waivers would prevent employees from joining together in a class action lawsuit, and that would be, obviously a very great benefit to an employer. They are enforceable. Again, there was a attempt by the California legislature to disallow class action waivers in arbitration agreements, but again, in AT&T Mobility versus Concepcion, the FAA preempts California law's attempt to ban as unconscionable agreements waiving class arbitration. That was also Supreme Court more recently ruled in Epic Systems Corp versus Lewis that class action waivers in arbitration agreements don't violate the Fair Labor Standards Act or the National Labor Relations Act and are enforceable. So again, they are enforceable. Next slide. However, the bane of California employer lawyers' existence, my personal existence as well, PAGA. This is the Private Attorneys General Act of 2004. It's been codified as part of California's labor code. It allows current and former employees to stand in the shoes of the California Attorney General and bring a representative action against an employer for violations of the California Labor Code. So each of those ticky-tacky wage and hour, minimum wage, meal and rest breaks, all sorts of wage and hour issues can be raised as a representative action, which is different than a class action. Plaintiff employees don't need to meet the same prerequisites or standards to bring a class action like numerosity or commonality, typicality, adequacy, notice, and certification. It confers on them a private right of action to prosecute their various labor code violations where penalties are stacked per violation, per employee, and per pay period, which for California employers of large numbers accumulate very, very quickly for even the most arbitrary infraction. It's long been a source of litigation over whether class action waivers can include also a PAGA waiver in a binding arbitration agreement. And it's still in litigation as we speak. Where are we? Well, relatively recently in 2022, we were employer lawyers were very excited about the Vikings River Cruises case. And that case basically held that an employee who had a PAGA waiver in their arbitration agreement had waived their right to bring in court their individual PAGA claim. And because that individual did not have standing or did not have an individual PAGA claim in court, it didn't have standing to represent others in a court. But then came Adolph versus Uber Technologies in 2023. That case basically said that even a PAGA individual or an individual employee who had settled their PAGA individual claim could stand and litigate on behalf of others in court. So it was unclear again. There are very recent amendments to PAGA that may change things. There were some changes to the standing laws and the standing principles of PAGA, so that may change it. So it's still yet to be seen where these amendments will take the standing of individual versus representative actions, but more to that on that in February at the next webinar. There are some best practices and things that we've learned while we're still, trying to figure out which ones are enforceable or not. Class actions waivers are enforceable, and PAGA actions, PAGA waivers, we still see them in client agreements, but it's important, and one of the pointers on this slide helps us make sure that to the extent it ever is unenforceable, or another statute comes out that makes a individual or a representative PAGA action unenforced or waiver unenforceable, if there is a strong severance clause, that it will help the situation, will help make the rest of the arbitration agreement enforceable. So one of the things that we ensure our agreements for our clients are mutual. Both parties have to waive the right to court litigation. Don't make certain claims in court versus others. It has to be clear, written in plain language, free of ambiguity, and this is important, translated into appropriate languages. We had a client who didn't translate a arbitration agreement into the native language of one of the employees who they sought to compel to arbitration, and that was not enforced. So it's very important that any employees who have, if you have a large Spanish-speaking community within your workforce, that you translate your arbitration agreements into that language. We have some clients in San Francisco who have a huge Chinese community, and that's translated into all the different dialects of Chinese. Accessible, you have to provide the sufficient time for an employee to review the arbitration agreement. That again goes to procedural unconscionability or conscionability. Include terms that comply with both California law and the FAA. Employers should cover the arbitration costs. A neutral arbitrator selection process should be included in the agreement. Reasonable location and procedures for the arbitration are clauses that should be in your agreements, and make sure that they're, like I said, a severance clause, just in case a statute comes along that attempts to make a certain additional clause or a waiver provision unenforceable. There are some recent changes to attempts by employers to enforce their arbitration agreements. It used to be the rule that courts could look at in St. Agnes versus Medical Center versus Pacific Air case. That was sort of the rule since 2003, that the most critical or determinative factor on a motion to compel arbitration is whether the party resisting the arbitration was prejudiced. That recently in July of 2024, the California Supreme Court held that things have changed, that courts cannot and should not consider prejudice to the party resisting the arbitration. Therefore, what does that mean? Now that prejudice is no longer the key issue, the courts look at the actions of the party to determine whether the right to arbitration has been waived. So if parties seeking to enforce an arbitration agreement should move to compel promptly and avoid engaging in conduct that suggests an intention to proceed in court. Courts are now applying more consistent principles to determine whether the existence of waiver under the California Arbitration Act or the FAA. It's really the party's word for conduct. So it's easier for the party who resists arbitration, it's usually the employee for our purposes, to show that the other party waived its rights. So courts are looking for signs of undue delay or gamesmanship to invoke an arbitration clause or to disregard an arbitration clause. There are some major changes to California arbitration in 2025 as well. California Code of Civil Procedure, Section 1283.1 was repealed. That was the statute that allowed, that basically said, except in cases of personal injury or wrongful death, depositions were only allowed in arbitration agreements if they were expressly provided for. And essentially this, because that was repealed, they now, all arbitration agreements in California are assumed to have the same discovery opportunities that they would have if they were filed in court. So interrogatories, depositions, the same. And so that's one of the biggest, more economic advantages to having an arbitration was pretty much wiped out by that statute. There also, the appeal of denial of the motion to compel, that was changed as well. Section 1294 of the Code of Civil Procedure, it used to automatically stay an action pending an appeal. That's no longer. It used to be often, I've had a case, for example, where we had a motion to compel arbitration that was denied, and it was in the Court of Appeal for 3 years, and it was automatically stayed. And that really worked to the benefit of the employer in that situation, but that is no longer. You can still make a motion for a stay, but it's not automatic. What do these two changes mean? It may not be procedurally or economically efficient to arbitrate disputes with employees in California, but it's even more important to make sure that you put in your agreements, if they can, to be under the FAA as opposed to the CAA, or the Federal Arbitration Act. We're getting close to the end, and I wanted to make sure that I couldn't do a labor and employment discussion without talking about how our workers in California, and particularly in Los Angeles, have been affected by disasters like the recent LA wildfires. I wanted to make sure that employers do consider these types of situations and what to do in situations of emergencies like these California wildfires. Please ensure, and employers should ensure, their employee safety and have an emergency communication plan. It could be included in that workplace violence prevention plan that we talked about at the beginning, but there really needs to be a place and a number or a person or some way to call the employer if there is a situation of an emergency like what we're experiencing here in Los Angeles. There are workplace and facility closure issues. We have the California WARN Act in addition to the Federal WARN Act that employers should consider, even if it's out of their control. And there's situations where we have buildings and businesses that are completely burned to the ground, but they still have to make sure that if they have workers in California, that they're complying with the California WARN Act for those closures. There's disaster relief resources for both employers and employees. California EDD has resources for impacted workers online. When we send out California WARN letters or federal WARN letters, we do point to these types of services for employees, and that same websites and California.gov website also has information for the California or Los Angeles wildfire as well. So it's important to share those with your employees if they're affected. Make sure that the health and safety of the workforce is being monitored. Right now, there's a big issue in Los Angeles of the air quality. There may be appropriate measures be taken by employers to provide PPE as needed, just as if a lot of employers were doing during COVID. Consider employee well-being, mental health resources, and flexible policies and accommodations. should be considered. Maybe there's opportunities for remote workers if they're displaced by the fires, for example. And it's important to look at your pay and leave obligations. There are California required pay and leave obligations that may kick in during situations of disaster as well. And I can help you navigate that in an emergency or just generally going forward, which I'll talk about in the next webinar. I think that's all I have for today. If we have time, I don't know if we have time, Debbie, to go through some of these questions.
I think we are right at the end of our time. So unfortunately, I did see one question about whether the slides will be distributed. And as I mentioned at the beginning of the program, they will be distributed to attendees within 48 hours of the presentation today. And as Amanda mentioned, we have a second webinar coming up on February 26th. I hope you've already registered for that one. We will present how to avoid pitfalls dealing with California leave requirements, wage and hour rules, and Amanda's favorite topic, the PAGA claims. So if you did have questions that were not addressed during our presentation, please contact your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, please contact Amanda or I, and we will discuss available options to address your particular needs and concerns. Thank you very much for joining us, and enjoy the rest of your day. Bye-bye.